Dear students, welcome back to the last class of this week, and today we are going to discuss about the Uruguay round of negotiations and also the WTO agreements and the formation of the WTO agreements, one of the watershed in the history of international trade. And the Uruguay round of negotiations played a crucial role in formulating these agreements, which ruling the international trading system for the last 26-27 years from 1995 onwards. And if you look into the Uruguay round of negotiations, so we saw the last class in the Kennedy round and the Tokyo round has played a very crucial role in formulating various codes and also reduction in tariffs. And these codes, the codes which was developed in the Kennedy round and Tokyo round, has finally negotiated in the Uruguay round of negotiations, which was started in 1986, ended in 1994. So, almost it took 8 years to conclude these particular agreements and to sign as a single undertaking. So, Uruguay round of negotiations are very important to understand the WTO agreements. So, in this class, we are going to see the Uruguay round of negotiations, what has happened in the Uruguay round of negotiations, and also the WTO agreements, what are those WTO agreements negotiated and finalized. So, we start with the Uruguay round of negotiations, and the Uruguay round of negotiations again happened. The members thought that another round, a final round is required to reduce tariffs and also to elaborate other areas of consideration, because the GATT system was playing a crucial role. The number of members has increased more than 100 and the participation has increased. The reduction of tariff also was happening, and the more number of international trade rules, for whether it is anti-dumping or it is subsidies or it is customs valuation. So, many codes are also negotiated during the Tokyo round of negotiations, and the Uruguay round of negotiations, it took more than 7.5 years, and which which ended the history of negotiation from the or I would say that the transition of GATT to WTO. And the GATT ruled from 1947 or 1947 to 1985, which was replaced by the agreements which was negotiated in the Uruguay round of negotiations. So, 123 countries participate in the Uruguay round of negotiations and which signed the WTO agreements. So, more than 30,000 pages, all the agreements, around 30 agreements and separate commitments, schedules and plus GATT, which constituted the WTO, almost 30,000 pages to the tune of which was negotiated during these 7.5 years. And again the tariff reductions to the tune of again 35 reduced from 35% to 6.4%. So, you can calculate how many percentage it is reduced, 35% to 6.4%. Substantial reduction of tariffs happened in the Uruguay round of negotiations. So, this enabled the free flow of goods from one part of the world to the other part of the world. We talked about in the beginning classes, we talked about the Silk Route, we talked about the goods traveling from Asian countries to the Middle East and or Middle East to then again back to the European countries. So, the countries made this possible, again it is possible through the WTO agreement and through the Uruguay round of negotiations. So, we can see comprehensive agreements concluded in the Uruguay round of negotiations, including the most controversial agriculture agreement. The multi-fiber agreement was replaced with the textiles and clothing agreement. New areas which were never discussed in the GATT negotiations came, that two additional important areas were services, trade related intellectual property rights, and the strengthening of the dispute settlement system. These are not only discussed, these are concluded, the appropriate agreements were concluded in the Uruguay round of negotiations. So, you can see that the Tokyo round codes plus these agreements and the GATT constitutes the whole WTO agreement. And tariff reductions, there is substantial global tariff reductions were declared. So, the final outcome of the Uruguay round of negotiations were almost 40% reduction, 40% reduction of tariffs. So, in the GATT itself, there is a substantial reduction in 1947. When it comes to 1995, there is a huge reduction of tariffs happened all over the world. And the difference is that in GATT there were few countries, starting with 23, and more than 123 countries participated in the Uruguay round of negotiations. So, we can see that the Uruguay round of negotiations come out with concrete agreements, improvement to the Tokyo round of negotiations, which strengthen the trade rules and come out with concrete agreements and divided into three major disciplines. These three major disciplines were, the first is goods, the second discipline is services, and the third discipline is intellectual property rights. So, the Uruguay round of negotiations successfully completed the negotiations on these three disciplines, and they reviewed all the Tokyo round codes only dealing with the goods in one discipline. They added the new sector, service sector, and also the trade related intellectual property rights, and also you can see one very important area, that is trade related investment measures, because the member countries, they were trying to form a multilateral agreement on investment. All the countries, including the United States and other countries, are trying to form a multilateral agreement on investment from 1945 onwards. They were not successful, but these countries thought that the WTO is the right forum to include these investment measures as well. But what is agreed is only trade related investment measures. When it comes to the intellectual property rights, most of the member countries are not parties to the Paris Convention, Berne Convention, Madrid Agreement, and there is a set of international agreements managed by the WIPO. So, these agreements, these countries were not willing to be a part of these international agreements. So, the developed countries indirectly wants the developing countries to agree to or protect intellectual property rights or the commitments under the Paris Agreement, the Berne Convention, industrial property, the copyrights under the Berne Convention, and then other intellectual property rights in whether it is, for example, the origin, the intellectual property is related to Madrid Agreement and other agreements. So, they thought that again WTO is the right forum to introduce intellectual properties as well. That is why we got trade, the agreement on trade related aspects of intellectual property law. So, all these moves are from countries. So, our perception is that these agreements are pushed by developed countries. For example, the case of in the case of TRIPS agreement, India was one of the country which given specific recommendation for the TRIPS agreement along with other 16 countries. So, the negotiating history says that it is not only the developed countries, but the developing countries are actively participated in the negotiations of the TRIPS agreement. So, it is not the case that only the developed countries were involved in the negotiation of the TRIPS agreement. Another very controversial agreement which we discussed and not agreed upon was agriculture, and a concrete agriculture agreement was negotiated upon, and the members agreed for certain measures, and these measures include subsidies to be reduced, market access to be given, and export subsidies to be reduced, the 3 pillars of agriculture agreement. So, basically the subsidies, which is the total amount, the aggregate measurement of support, they agreed to reduce 20%, and also they decided to put these subsidies under different categories, so that the immediate requirement of reduction of subsidies, some of the subsidies like blue box, and some of the subsidies to be allowed, they put it under green box, and some of the subsidies are declared as prohibited subsidies, and members were asked to reduce substantially export subsidies, and this was agreed upon. 36% was agreed upon on all budget outlays of all the countries. This is very difficult for the developing countries to reduce, but the fact shows that United States and European Union also give huge amounts of subsidies. And another important agreements were the removal of non-tariff barriers, which we discussed about as SPS and TBT agreements, and which we will discuss it in detail again. So, non-tariff barriers in not only in agriculture trade and in other trade also to be eliminated. So, they come out with agreement on SPS, this sanitary and phytosanitary agreement, technical barriers to trade TBT agreement also concluded in order to eliminate non-tariff barriers. Then the most importantly, the textile sector was completely a mess before 1974, because every countries allowed quota system, and not only quota system, and but also you can see the quantitative restrictions were put on textile exports. So, this find the producing countries like the Asia and Africa find it very difficult to export cotton to other countries, and this was finalized with the multi-fiber agreement, which was as negotiated and finalized in 1974. This agreement, this multi-fiber agreement was replaced by the agreement on textiles and clothing in the Uruguay round of negotiations. We said the new additions, new discipline added was trade in services. General agreement on trade in services were included in order to it's specifically to discipline in the area of international trade and investment services, movement of people, because the services can travel from one country to the other country. There must be rules and regulations. The most far reaching the consequences was for the services agreement. So, the services agreement, most of the countries are benefited by providing service, and the disciplines were prescribed, the rules were prescribed under the trade and services agreement. So, the many countries are is benefited, many countries are benefited out of this service agreement, and one of the country mostly benefited are India. The Indian contribution to the GDP has even rose up to 60% or even the 60%, to the tune of the contribution to the GDP is on service sector. So, the total industry and the industry as well as industrial contribution plus agriculture is hardly 40%. So, services become one of the most important agreement negotiated in the Uruguay round of negotiations, and some of the countries are immensely benefited out of this particular agreement. So, we were talking about the TRIPS agreement. The TRIPS agreement, we already said that most of the countries were not parties to the Berne Convention or Paris agreement or other agreements which was managed by the WIPO. So, all these commitments were clandestinely put in the TRIPS agreement by the negotiators, and total there is 7 categories of intellectual properties included in the TRIPS agreement. You can see that patents, copyrights, trademarks, appellation of origin or geographical indications, patents, industrial designs, designs of integrated circuits and trade secrets. So, the TRIPS recognized 7 categories of intellectual property law under the TRIPS agreement, and the TRIPS agreement provided minimum standards for intellectual property protection at the domestic level. For example, the term of protection of patents, and they uniformly fixed as 20 years. So, it means that 164 WTO member countries are going to follow the uniform term of protection of patent for 20 years. So, basically the TRIPS agreement gives a minimum standard of protection at the domestic level. At the same time, the members are given the freedom to come out with their own legislations dealing with this particular protection of intellectual properties. So, TRIPS agreement become one of the most important component of Uruguay round of negotiations. Now, the dispute settlement. The GATT system, the GATT dispute settlement was loosely arranged, and most of the reports were not adopted because of the opposition from the members. Now, the new dispute settlement system was adopted, and there is no question of veto by the members or the parties, and a negative consensus system was adopted. So, if majority of the countries are only object, then only it is not going to be adopted, and it is not happened for the last 25, 26, 27 years. It has never happened and not a report is adopted. So, a stronger system or dispute settlement system was adopted with the 2-tier system. The panels and the appellate body has been established under the dispute settlement system, and dispute settlement system works as the cornerstone or strong support to all the agreements for the dispute settlement in each and every field. So, when we look into the Uruguay round of negotiations, which is happened first time in a developing country, a country like Morocco. So, it has happened in Marrakesh, Morocco, and which come out with fantastic results, and also which you can see that with lot of disciplines, new areas are covered under the Uruguay round of negotiations. So, finally, the agreement was signed in 1994, finalized in 1994, and which came into effect of 1st January 1995. So, This agreement, the new agreements came into effect from 1995. And what happened to the GATT? The GATT agreements also become a part of the WTO agreements. They continued to, these basic agreements are continued to be a part of the WTO agreements. So, the Uruguay round of negotiations was a package of GATT plus Uruguay round of negotiations equal to WTO agreements. So, all the codes, plurilateral agreements were added to the WTO negotiations or WTO agreements. So, if you ask whether GATT was a success for a period of 47 years, I would say that GATT was highly successful in reducing the tariffs, highly successful in negotiating new areas. They disciplined a lot of areas like anti-dumping, subsidies, safeguards, non-tariff barriers, and they come out with other areas like services, intellectual property. So, you can see that the Uruguay round of negotiations or the Tokyo round of negotiations or Kennedy round of negotiations and all these negotiations contributed to developing the WTO agreements, which was a highly successful period of GATT success and which reduced most importantly the tariffs and set minimum standards for various areas. So, people ask what happened to the GATT, whether GATT is dead or alive. The GATT is very well a part of WTO agreements, and GATT is never dead. All the GATT agreements are part of the WTO, very much it is a part of WTO agreements. So, GATT continued to be a part of WTO agreements. When it comes to the WTO, and everybody knows that it is an intergovernmental organization which was born out of the Uruguay round of negotiations, and it is a continuation of the GATT arrangement, and it is the basic objectives continued the earlier objectives of GATT, primarily removing barriers and lowering barriers, and also to liberalize the trade. It is not only for liberalizing trade, but it is a forum for negotiations, and it is also maintaining, reducing trade barriers, protecting consumers and preventing from diseases, not only to human beings, human health. It talks about plant health, animal health, and removing trade barriers. It talks about standards. It talks about developing international standards. And also we can see that WTO become a rule based body. So, it made the basic rules for the international commerce and trade, and which is binding on the members. WTO agreement is not a soft law, it is hard law, all are binding and to be signed by the governments at a single undertaking. What do you mean by single undertaking? So, if a member wants to sign only the goods agreement, they cannot sign. They have to sign the goods agreement, they have to sign the TRIPS agreement, they have to sign the services agreement, they have to sign the dispute settlement body agreement. All the WTO agreement has to be signed as a single undertaking. So, if somebody says that I do not want to sign the TRIPS agreement, they cannot become a part of WTO. So, it was a single undertaking, and the cardinal principle of WTO is continued to be the cardinal principle of GATT. The first one is the most favored nation treatment. So, treating people equally under the WTO agreements. So, countries cannot normally discriminate between their trading partners. So, if you do a favor to one country, you have to provide to all member countries. So, in general, it means that if you reduce a tariff for one country, it has to be provided to all countries, whether rich or poor or developing or developed countries. So, most favored nation treatment is made it treat all trading partners equally. And the second cardinal principle is the national treatment. And here the treating foreigners and locals equally. It means imported products and locally produced products are treated equally, and that means if you provide any kind of incentives to the domestic goods or domestic products or domestic services, you have to provide it to all the people, even the foreigners, those who are importing that particular goods or services. So, you can see the national treatment principles in GATT also. You can see the provisions in GATT service agreement. You can see the provision in TRIPS agreement as well. So, national treatment made it's a non-discrimination provision between the domestic producers and foreigners, the foreign producers. So, these are continue to be two cardinal principles of WTO. So, these two principles in all transactions has to be complied with, even in the case of taxations. So, lowering tariffs and lowering trade barriers is one of the important objective of WTO. Customs duties to be disciplined, customs duties to be implemented fairly, non-discriminatorily, and you cannot put import bans or you cannot impose quotas and other restrictions under the WTO agreement. So, it means that, and the license right system has abolished by the WTO, and the WTO made the Indian international trade more predictable. The rules made it transparent. All the country rules should be published with the WTO. It increased transparency, it increased predictability, and increased stability. And through the TRIPS agreement, it enabled investments, non-discrimination investments in all the countries. The basic principles of trade related investments also is implemented through WTO. So, the multilateral trading system has played a crucial role in the international trade, and more importantly, it played a fair competition, promoting fair competition, and it promotes free trade, and it promotes non-discrimination. It disciplines dumping, it disciplines subsidies, it disciplines safeguard measures. So, unfair trade cannot happen under the WTO, and it encourages development. There is special provisions for developing and least developed countries. There is flexibility for the developing and least developed countries. So, these provisions are inherited from the GATT provisions. So, the WTO encourages development as well in developing countries. So, the best evidence, this is the World Bank data again, which says that, so what happened after 1948, the formation of GATT to the entire GATT period of 47 years, 1948 to 1995. So, you can see that the GDP, the trade and GDP, both the merchandise trade and GDP of countries has increased greatly from the formation of GATT to the 1995. You can see that the points, the development is unparalleled, uncomparable from 1948 to 1995 during the Uruguay round of negotiations. So, the last class we saw that the development from 1995 to 2023, no comparison other than economic slowdowns, you can see that the merchandise trade has increased in a period of time. Since 1995, the world GDP has also increased. So, the GATT to WTO journey is unparalleled and every country has benefited out of WTO. So, some of the scholars or critics of WTO says that the developing countries become more poor and the least developed countries become poorer, but the data says it is not correct. So, you can see the lines, you can see the graph, what happened from 1929 to 1938, you can see in the same graph. So, there was great dip and most of the economies are suffered, and these same countries has emerged like a phoenix bird from 1948 to 1995, and the graph shows the development very clearly. This is the evidence. So, the scholars are not correct that the developing countries become more developing and the least developed countries become poorer countries. That argument cannot be accepted, because the data shows that these countries are become benefited out of the GATT and the WTO. So, quickly we will go through, we have a scan of the WTO agreements, and so what is concluded in the Uruguay round of negotiations. So, you can see that there are multilateral agreements on trade in goods, then the GATT itself, the GATT is a part of WTO, then starting with the agreement on agriculture, then agreement on the application of sanitary and phytosanitary measures, agreement on textiles and clothing, the agreement on technical barriers to trade, and agreement on trade related investment measures, the agreement on implementation of article 6 of the GATT 1994, that is the anti-dumping agreement, agreement on implementation of article 7 of the agreement again the GATT 1994, that is the subsidies and countervailing duties agreement, agreement on pre-shipment inspection, agreement on rules of origin, agreement on import licensing procedures, agreement on subsidies and countervailing measures, then agreement on safeguards, then the general agreement on trade in services and the annexes, country annexes attached to the agreement, then agreement on trade related aspects of intellectual property rights, the TRIPS agreement. Then the most importantly, understanding on rules and procedures governing the settlement of disputes, the DSU agreement. Then there is a special provision for trade policy review mechanism of every country for 2 years, every 2 years. Then the plurilateral agreements like the agreements on trade in civil aircraft, government procurement, and even dairy agreement and bovine meat agreement, which you can find it. These agreements constitute around 33,000 pages of which constitutes the whole WTO agreement. Quickly we will see, we will take few minutes to understand what is this WTO. WTO is an organization and fully an organization unlike GATT, which is presently located in Geneva, established in 1st January 1995, created by the Uruguay round of negotiations with a membership of 164 countries now, and observer countries are 25, and the secretarial staff of GATT again has joined the WTO with many other staff from many member countries, which is the 99.99% of the world trade is controlled by only a secretariat staff of 620 from various member countries. And the present head of the organization is Gosi Okonjo Iweala, the first African lady. The first lady Director General of WTO is presently the head of WTO, and her term is up to 2025. And we can see that the functions, the main functions of the WTO is administering the WTO agreements. It is a forum for negotiation, it is handling trade disputes, and it is monitoring national trade disputes as well as the trade policies, and it provides technical assistance. Quickly we look into the organizational structure of WTO. You can see at the top the ministerial conferences. The ministerial conference is the membership of all trade ministers of all 164 countries, and also you can see the main bodies. The main bodies includes the committees. The first committee is, you can see, on the committee on goods, and then dispute settlement body you can see. Then the general council, you can see general council. Under general council also there are different bodies. Then you can see the general council on intellectual property, then general council for trade and services, and then there are the appellate body also. You can see the appellate body is CITAS. So, the ministerial conference CITAS, the appellate body, and also the plurilateral agreements which you can find. So, the different committees includes, for example, the WTO has constituted the committees for studying the new subjects like trade and environment, trade and development, then subcommittee on least developed countries, regional trade agreements, balance of payment restrictions, budget, finance, etc. So, trade in goods includes all the agreements which come under the goods. So, the Council for Intellectual Property Rights just look into the intellectual property rights. Services look into the Council for Services look into trade and services, and then plurilateral agreements. So, if you elaborately look into, you can see that the ministerial conference at the top, and which sit as general council, and this general council sit as or you can say that as monitoring as dispute settlement body, and also they can trade policy review body, and also you can see the appellate body. So, the dispute settlement body as part of dispute settlement body, you can see the appellate body as well, and also the various. So, this particular picture shows, this figure shows the entire WTO the organizational setup, and even the 2002 Doha Development Agenda also, and also the topics are also shown in this particular picture. So, this is the basic organization structure of WTO, and which is controlling all the entire international trade. So, we already covered the GATT and its origin and its membership, which is a small organization started with 23 original members. We said that which includes India, and you can see that the countries, those who are started the GATT in 1947, and the very few countries like Australia, Belgium, Brazil, Burma, Canada, Ceylon, that is Sri Lanka at that point of time, Chile, China, Cuba, Czechoslovakia, Czech Republic at that point of time, France, India, Lebanon, Luxembourg, Netherlands, New Zealand, Norway, Pakistan, Southern Rhodesia, Syria, South Africa, and United Kingdom and United States of America. These are the original 23 countries, those who contributed to become a member in the GATT, and presently there are 164 member countries. So, very few countries are left. So, it means that if you look into the difference between the GATT and WTO, quickly we can say that GATT was not an organization, GATT was only an arrangement or an agreement, but WTO is a permanent institution and it with its own secretariat. And the GATT measures were applied on provisional basis, but the WTO agreements are permanent, and the WTO commitments are full legal international commitments, and the GATT rules are applicable to merchandise goods only, but the new areas like intellectual property and services are added to the WTO. And also you can see that these agreements, the GATT agreements, the multilateral instruments and plurilateral agreements, and many agreements are added to the GATT, the GATT original GATT agreement. And also the dispute settlement system was very weak in GATT, and the WTO, a strong WTO dispute settlement system is established. So, WTO is a sui generis organization and it is not a specialized body of United Nations. It is an independent organization, but a working arrangement is made between the WTO and the UN. And the objectives which we have already looked into, the objectives of WTO and its functions. Its functions are very clear and it administers all the WTO agreements and it is a forum for negotiation and it manages the settlement of disputes and administers the trade policy review mechanism and also provides technical assistance to developing countries for implementing the mechanism. So, the rules which we already talked about and the Marrakesh agreement also, which we already saw the Marrakesh agreement and the different agreements and its hierarchies. So, we can see that the WTO agreements are the bedrock of the Uruguay round of negotiations and these WTO agreements are going to be there, some of them like agriculture agreement are not completed, but the basic agreements are signed. So, in the coming classes we are going to discuss about the important agreements in this, not all. So, it is a 8-week course and we are not going to get time for discussing all, but we are included all important WTO agreements in this particular course. And in conclusion, I would say that presently WTO is an agreement dealing with 99.9% of the world trade and which is a strong rule based system and a very strong dispute settlement body, and its implementation is as a international agreement and it is a forum for discussion and it is managing very well the WTO agreement from since 1995. So, we will stop here at this particular class and from next class onwards we will be dealing with individual agreements, individual WTO agreements. Thank you.